You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 100. You're kidding me. How much is this going to cost? My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. We did it, my friends, 100 episodes. I've been a podcast and information junkie for a long time. I listen to all my podcasts at 2.5 speed and YouTube videos and learn things at 2 times speed. I've heard some of my listeners also listen to my podcast at super fast speeds. And when I started my own practice, I thought it'd be really fun to do my own podcast. And after 100 regular episodes and a few bonus episodes, I think I really cover the basics of the entire patenting process. But with some tidbits in other areas of intellectual property, like a few trademark and copyright episodes. And if you made it through all 100 episodes, you probably actually know more about some areas of the patent process than a lot of patent attorneys, because a lot of patent attorneys have paralegals that do all the nitty-gritty stuff that I went over with you, because I'm trying to give you at least the basics for how to do things yourself. Now, I've had several people connect with me saying they've listened to my podcast and filed their own application, and now they want me to take over. And I have to say that sometimes they either didn't listen to my podcast well enough, or they listened, but maybe 10 minutes on a podcast in each topic just isn't enough information for you to always do the best job. Or maybe it's a little bit of both, because many times I've just had to start over on what you've done, and then I have to do it right. So sometimes just hiring a patent attorney would have been better to start with, but hopefully if you've listened to the episodes, you at least have an idea on what's going on, even if you use an attorney in the end. So I'm really grateful to all my listeners, especially those who have contacted me. And if you've been listening to my podcast in silence, still love to hear from you. Just drop me an email, and you can even propose some topics for me if I haven't covered them. But I think I've mentioned everything that can happen during the patenting process, which is why after this momentous episode 100, I'm probably going to slow down on the weekly releases and release more bonus episodes with interviews of entrepreneurs or other people involved with inventions outside of the patent space. Or maybe I'll just do some question and answer episodes. If you guys email me some questions, I could put a bunch of them together and just do another episode. So I thought I'd end my regular podcast journey with you guys with a question that I probably get most often from people, and it's, how much will X cost me? And that can be anything from trademark search to filing a patent application to getting a patent issued. Now, before I became a lawyer, I always hated the answer, it depends. I just want a lawyer to give me a straight answer, and they never would. Everything just depends. And I said, when I become a lawyer, I'm not going to say it depends. I'm going to give an answer. And guess what happened? I say it depends all the time. And I'm not proud of it, but it's just the truth. Luckily for the type of work that I do, a lot of what I can do is flat rate. I don't do litigation directly anymore. I work with other people that do litigation, so I can help with that and be a part of a team. But I don't do litigation. And in litigation, it really depends. It depends how much litigating costs, because it's almost always done on an attorney hourly basis, and cases can be settled really quickly or they can drag on for years. But for patent prosecution and prosecuting trademarks and filing copyrights, lots of times I can make estimates because things come in short steps where I can estimate my time and cost pretty well. And I just want to give you some rough estimates on what you can expect with going with an attorney. I do have estimate ranges on my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. You could also get to it from patentingforinventors.com. It just goes to the same place, but sometimes it's easier to remember that. But I'll go over some of these costs here. Let's talk about patents first. Sometimes someone will call me and say, how much will it cost me to get a patent? Well, that really depends. Maybe it will be several $1,000s if everything goes smoothly. But if your application gets rejected and you want to appeal all the way up to the Supreme Court, then you're talking hundreds of thousands of dollars. But let's break it down into pieces. How much will it cost to at least get my application on file? That's usually kind of the first thing that people want. They want something patent pending. These are just estimates, but for something really, really simple like a tie clip, it might be in the $5,500 range. If it's medium complexity, maybe a small automobile part, maybe around $7,500. If it's really complex, like a biomedical device or pharmaceuticals, it could be $9,500 or more. Also, make sure you know what's included in that cost. Are patent office filing fees, search fees, examination fees included? Are the drawings included? Is there a separate cost for preparing assignments or preparing information disclosure statements? You just want to know what you're paying for and what you're not paying for. I like to give a flat rate that covers everything up to filing, which includes all the forms, the filing fees, information disclosure statements. But sometimes I start working on an application and realize that instead of being able to describe the invention in 3 figures, that it will take me 25 figures. I mean, that's a really high amount of figures. And that just costs a whole lot more money. Draftsmen will generally charge between $25 and $50 per figure. So I usually say in my agreements that the flat rate will cover up to 5 drawings or something like that, and extra drawings will cost extra. So that's typical for filing applications, but maybe you don't have that kind of money. Then what can you do? You can file a provisional patent application. Those prices can really vary because it depends how much work you want the attorney to do. One option is that you provide the entire detailed description and pictures and drawings, and the attorney will just put it all together in a package and file with the patent office. And I generally charge about $1,000 for that. But if you want the attorney to write up the provisional application himself, then that cost actually isn't going to be that much different than a regular non-provisional patent application. It might be a little bit cheaper, but not by much. So provisional maybe could be in the range of $1,000 to $4,000, maybe more. It just depends on what you want the attorney to do. A couple other application costs. If you're doing a PCT application, and I talked about all these different kinds of applications in previous episodes, you're talking maybe about $2,500 more than a U.S. application because the filing fees are higher. What about design applications? That might be about $2,000 to $3,000 depending on the complexity and how many figures you need in your application. So what about some other things even before you file an application? You want a patentability search and opinion. It depends on the complexity, but it might be between $1,500 and $2,500. You can always do a patent search yourself, and I talked about that in an early episode, which is always recommended that you do something yourself. But if you want an attorney to do it, those are costs that might be typical. One thing you want to be careful about in patent opinions is find out whether you're getting a patentability opinion or an infringement opinion. A patentability opinion is a lot less expensive than an infringement opinion, also called a freedom to operate opinion. And that's if you want to find out if you're infringing any patent out there. Now, these freedom to operate opinions, they might be in the $6,000 range or higher for something even without much complexity. It's just a much more intensive project, and a lot more detailed reading has to go into whether you're infringing anyone else's patent out there compared to just whether trying to figure out your invention is new and non-obvious. So what about rejections? How much does it cost to respond to a rejection? If it's a simple rejection without too many prior art citations, it might be about $2,000 to $3,000. What about foreign patents? Remember, there's no such thing as a worldwide patent. You have to get patents in each country or regions of countries that are part of a group. So you're talking, literally, if you wanted a patent that covered every single country, it would be over $1 million. But nobody really does that. You have to figure out what countries are important to you. Every country has their own attorneys, and just as a rough estimate, if you already have a U.S. application on file, you might expect to pay between $3,000 and $8,000, depending on the country or region, just to get your application on file, because you have to pay my fees, then you have to pay the fees for the other attorneys in the other country, you have to pay the other country's filing fees, so all these things just add up. Then once you get a patent, some countries, pretty much every country, will have you pay either yearly fees or every few years you have to pay a fee called a maintenance fee or an annuity fee to keep your patent active. You might pay a few $100s to several $1,000s each year. So by the end of it, if everything goes smoothly from when you file your application, from when you want to file your application, to the expiration date of when your patent ends, on the cheap end, you might be thinking of, it might be about $10,000 to maybe $25,000 on the more expensive end. And there are countries that require translations of the patent, and you really can't use Google Translate. You really have to use a professional patent translation service, and that might be about $1,500 to $6,000, depending on the country and how long your patent is. The longer your patent is, the more words there are to translate. So I really don't recommend foreign filing if you're just an individual inventor. It's just too expensive, And instead of focusing on protecting your invention throughout the world, just focus on the US, where you can really have the resources to enforce your patent. The exception would be to maybe file a PCT application so that you have the opportunity, at least, to file worldwide patents later. And by the time you have to file applications in other countries, maybe you have some big investment in your invention, and you really can pay for patents throughout the world. But if you're not willing to spend $10,000 to $25,000 per application at the end of the whole thing, then you really have to, and that's per country, then you really have to consider whether patenting is the right approach for your invention. So those are some numbers to keep in mind. I didn't even go over cost to appeal and more particular situations where it just gets more complicated and harder to predict. I didn't go over patent litigation, and you're easily talking hundreds of thousands to several $1 million for that. Let's talk about trademarks for now. On the cheap end, you have to pay at least $225 currently to the Trademark Office to file an application. And that's whether you do it yourself or have an attorney do it. So you're on the hook for that no matter what. For me, if it's a simple trademark in one class, I'll typically charge about $700, and that includes the filing fees. If you want a trademark search and opinion, that might be about $1,000, but it depends on whether you want foreign searches, common law searches, state searches, whether you want to look at domain names and all the other things that might affect you being able to use your mark. Responding to trademark rejections, like let's say your application was rejected because it was considered confusingly similar to another mark. Responding probably would start at around $700, but it can be higher if it's more complex. You do have to submit paperwork to the Trademark Office after your trademark issues to show that you're still using the mark in commerce, and that might be about $600 to do all the forms and all the paperwork to get that going. There's something called a Madrid Protocol application, which I talked about in a previous episode, where you can simultaneously apply for trademarks around the world. And it depends on how many countries you want. But it might start at around $1,500. For something more complex and more countries, $2,500. Let's talk about copyrights now. To file a copyright, generally it isn't that complicated, but it can be complicated if there are multiple authors, you're doing a derivative work of someone else's copyright. But for simple things like you want to copyright a picture or a manual for your invention or something like that, it would probably start at around $300. So these are some typical fees, but everything can vary. There are 6 words you should never expect to hear from your patent attorney. This is going to be cheap. It's not. And you just have to be prepared for that. Any attorney that says that it's going to be cheap is probably just trying to hook you in, and then will surprise you with costs later on. I like to be totally upfront with costs as much as I can with my clients. Yes, there can always be surprises, but I'll actually tell you that there can be surprises, and I'll try to anticipate what those surprises might be and what those costs might be as well. I hope you've enjoyed the first 100 episodes, and that my podcasts have been useful for you. We'd love to hear how my podcasts have helped you in any way. And feel free to send me any questions you have. Maybe I'll do some bonus episodes where I get a few questions that I could answer and I put them all together in an episode. And also expect some more bonus interviews from me in the future. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamantpatentlaw.com or call me at 424-281-0162. I'm Adam Diamant, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamant. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamant at patentingforinventors.com. That's patentingforinventors.com. Or call Diamant Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.